Welcome, and thank you for joining us for today's webinar on navigating today's practice legalities, proudly presented by PracticeHub and Avant Law. In the spirit of reconciliation, PracticeHub acknowledges the traditional custodians of country throughout Australia and the connections to land, sea, and community. We pay our respects to their elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples today. Thank you for joining us for the latest PracticeHub webinar. As this topic is particularly broad, we will be focusing on some of the legal issues that practices need to be across or may be encountering. On our panel this afternoon, we have Michael Swan, who leads the civil team of Avant Law solicitors in New South Wales. Michael has over 20 years experience as a solicitor, acting for and advising defendant medical practitioners in a wide range of civil actions in the state and federal jurisdictions. Joining Michael, we have Stephen Schoninger, who heads up the employment and workplace law practice at Avant Law in Sydney. Stephen has over 18 years experience practicing exclusively in employment, industrial relations, and discrimination laws. And finally, we have Anna Maria Gibb, the co-creator of My Practice Manual, now PracticeHub. Anna Maria has a background in practice management and qualifications in business and adult education. I will now hand over to you, Anna Maria.
Fantastic. Thank you very much for that, Katrina, and welcome to all of you joining us today. It's very exciting to see how many people have registered for this webinar. It's obviously a topic of great interest. So before I hand over to our speakers, a quick overview. We're going to talk about practice systems and system errors in recalls. We're going to talk about parental or guardianship rights, including the access to records and consent to treatment, and living with COVID-19, I guess, something we're all dealing with, and the policies and mandates that apply to that. And finally, we'll be talking about casual employment for medical practices. And after that, I will do a demonstration of how all of this ties together with PracticeHub. So I'd like to hand over to our first speaker, Michael, if you'd like to take it away, please.
Thank you, Anna Maria. I'm Michael Swan. I'm a solicitor here at Avant Law, and thanks for joining us today. I'm just going to be talking about three different issues. They're quite broad issues, so I probably won't have time to cover off on each particular issue completely, but feel free to ask questions in relation to those issues. I'm going to be talking about things that you would normally, calls that I would field on the medico-legal advice line in relation to Avant from practice people like yourselves. So if you have any questions as we go along, feel free to put them in and I'll try and address them as we go. One of the most common things that we see from practice managers and practice staff are queries about access to records from one parent or another. Typically, a patient under 18 will come into the practice and have a consult. They'll come in either with one parent or not with a parent. And the other parent will ask for a copy of the records or ask what's happened in the consult. And the background to that is some dispute between these two parents. And most practice staff want to run 100 miles from any sort of dispute between other people that aren't related to what's going on in the practice. So there are a couple of concepts that we address in these sort of calls. And there's a couple of different reasons you can refuse access, but it's only really limited sorts of grounds. And they're things like if it poses a serious threat to the life or safety of the patient or anyone else, if it unreasonably impacts on the privacy of others. Now that can relate to, for example, if there's information about someone else in the records. So not only information recorded about the patient being seen, but someone else, and typically that's in relation to some other parent. Also, if it's unlawful to disclose that information, and sometimes it's in relation to legal privilege, which is normally documents or things that are in preparation for litigation, which doesn't happen very often, thank goodness. And so in terms of dealing with these requests to access the records, you have to consider things like, has the patient given consent? How old is the patient? Are they a teenager? Is there some sort of other background thing happening that makes you consider a reason why you wouldn't give access? For example, is there some sort of threats behind the scenes? And typically those are the types of things that when you have dilemmas, I guess, like that you typically ring the medico-legal advice line. And the other thing is you can also get subpoenas, which makes it more straightforward because you're compelled to produce. And therefore there's no sort of should I or shouldn't I. It's an order of the court and you produce. In relation to a third party or a child, you have to consider whether the parent consents. Both parents. Do you need both parents' consent? Well, no, you don't. The age of the child in terms of, are they under 14? Are they in that 14, 16, 17 year mature minor category? And that's where you have to consider whether they've got capacity or sufficient understanding and intelligence to enable the child to fully understand what is proposed in terms of, typically when you're seeing them in the practice as a patient. But in terms of access to records, you really have to consider their wishes in terms of whether access is granted or not, in conjunction with the parents' wishes. And also, hopefully, there's some court orders out there in relation to access. And I think only one time in 20 years I've seen court orders that say only one parent is to have control over the child's access to healthcare. Every other time it's been both parents are responsible, and that's typically what happens without court orders, that both parents are responsible for looking after the child. The other thing that we see typically in civil claims and also in phone calls are things like recall. We're trying to find a patient, we can't find them, what do we do? And I guess there's a couple of mainstays to consider in relation to that. If you're part of a recall system, you need to know the whole system, not just your part in it. And what is the practice policy on recalls, and does it work? Do you see any problems with the way the practice is doing recalls? And it's really about having a system that enables you to recall patients based on their results. Some people say, well, we recalled them, they didn't come back, and it's of little consequence because their result was in relation to something that they would have come back in due course for anyway. And I think it's important to think about how these systems can be improved and to avoid claims and complaints in relation to it. I think one of the most important things is before you have to recall. So gathering accurate information when a patient presents. So an accurate contact detail, mobile number, and is it updated at every visit? Do you typically ask a patient when they come in, okay, you're still living at the same address? Is this the address? What's your current phone number? Those sorts of things can be a piece of information that's really valuable if you're trying to follow up. And also, what's the plan in relation to these results? What happens if they're, say, positive? What are we going to do then? How are we going to convey that information to you? How do you want it presented? Do we want it sent to your family email address? Or do you want to come back and get it in person? And that might depend on what sort of result is it? Is it your STI results? Or is it results of some sort of cancer biopsy? Is it your blood results for results you have for INRs, for example, for coagulation? So each of those things has a different gravity or a degree of confidentiality that you might want to consider in terms of the patients and how they would want to get it delivered. The other things that you might want to consider in relation to system recalls is whether you have a stage approach and what's that based on. You say, well, what are you talking about, Michael? It would be things like gravity. So, for example, I'll just talk about a case that I was involved in a few years ago, HIV results. What is the gravity of having a person who doesn't know they're HIV positive out there in the community? They're a young person, they're sexually active, they're not necessarily having one sexual partner. Well, the gravity might be that they give it to someone else. And so what lengths do you have to go to? Recall that patient and tell them about that particular issue. And I was just talking about a case and you were wondering what goes on in recalling patients. Well, that was one thing that went wrong. So they didn't have the correct contact details for the patient and they're unable to find the patient until they'd passed HIV to someone else. The other thing that we see are systems that haven't been thought through or not followed. So you might have a recall book and there'll be a whole range of different things that you need to recall patients for in that book, and something gets missed in the book. It's not transferred onto another page for another day, and it just doesn't get recalled. Things like Pap Smears. Now there's supposed to be a backup system for the National Register of Pap Smears. If they haven't received any further information about further investigations, they will send a GP practice a letter saying you haven't tell us any further about this patient? Have they been followed up? So it's like a reminder. Sometimes that doesn't happen. So sometimes things fall in the cracks, and that's when typically I see them. And the other thing is systems upgrades or outages. So maintaining and backing up your system is really important in terms of having accurate information, but also a system that works without corruption. And I thought I'd leave this one blank because the New South Wales rules seem to be changing all of the time. And it's something that impacts practices, I guess, in terms of mandates, which are the New South Wales rules in New South Wales and other state rules elsewhere about face masks, physical distancing and vaccinations. So I was just having a look at the current rules just before the webinar. So at the moment in New South Wales, it's mandatory to wear masks on public transport, in a public hospital or private health facility, including private hospitals and day procedure centres, at residential care facilities or hostels, on aircraft, in a cruise terminal. And there's also a mandate that venues can set their own COVID-safe conditions of entry. So in addition to the public health order requirements, some premises may choose to require people to be fully vaccinated or wear a mask as a condition of entry. And it's a matter for the occupier of each premises to exercise judgment on what is appropriate for their premises, well-being of their staff and their customers. If you want to enter premises where an occupier has chosen to require you to be fully vaccinated, occupier may ask to see your vaccination evidence. You don't have to show it to them, but they don't have to let you in. So I'd be interested in everyone's comments in relation to their experiences of having a policy within a practice without a government mandate to back it up, because we are having a lot of queries about that at the moment. Just have a look in the chat just before I hand over to Stephen. So I've received a message from an unknown person wanting to check if their late father attended our clinic. How do I deal with that? Well, you have to know who it is, first of all, and you'd have to know the details of who their father was, and you're entitled to check the bona fides of that particular person. You might want to ask them for some evidence to say that it is in fact their parent. So you might want some sort of birth certificate, which will have it on it, a will, some sort of evidence of that. But yeah, that's probably not enough to give them access to the records just based on that. Young adult, yes. So a common issue around when there's a young adult independent of their parents, often have 20-year-olds where parents demand medical information about their children. Yeah, that's pretty common. If they're 18, they're an adult. They can decide whether their parents have access to their records. And when they're even younger than that, say from 14 to 18, in that sort of mature minor space, you want to go with their wishes in relation to giving access or not to their parents, although their parents have the ultimate say. It might have more about that might be more about their family dynamics than anything else. So the answer to that one is, if the patient consents, you can give them a copy of the 20-year-old's notes. You would want to document the request and the consent of the patient. So typically requests for information also have to be in writing. So there's an adult requesting consultation notes. Do we have a duty to provide to them? Yes, if it's in relation to themselves. You might want to ask them why. It might be better dealt with by facilitating some sort of explanation of the records, because sometimes, or a lot of the times, people have no idea. It's like speaking a different language, looking at medical records sometimes with the abbreviations and words, and not everyone's able to interpret that language. And so it may be that needs to be facilitated in some way, and it's subject to those exceptions that I said at the start. Okay, if a patient asks for their whole file, do we have to? I know that a lot of patients have been going to a single practice for many years, and some have like copious records. I think it's a good idea to try and clarify with them exactly what they want out of those records, because that makes it a lot easier rather than just printing it all out. I think as a solicitor, you want all the records. If it's from a solicitor or from, in terms of legal proceedings, I think it's quite important to give all the records. Some of the difficulties that we see are when all of the records aren't produced. For example, if the records like a consent form from a procedure, then we see allegations that the patient didn't consent for the procedure when in fact, that's a sort of key document that we see sometimes. Specialist letters, if they're not produced, then allegations are made in relation to not referring or not conveying information. So things like that. So it is important to produce it all. I've got another question here. Emailing results. Yes, it's good to encrypt them. Here's a question from Rachel. If you have a mature minor present for a consult with a parent and then the parent asks for results, can you assume in that situation it's okay to provide? I think that goes back to what I was saying before. You need to set those things up early on if you can, to say, what are we doing with these results? I think you can assume that it's okay to provide them. However, you'd want to check with the patient somehow if you can do that. And it really depends on the results, I guess. Is it a beta HCG that you're giving them a result for? So it's about gravity again. So yes, the doctor should be asking at that point if they give their consent. That's right. And they should be saying, what are we doing with these results when they come in, no matter what they are? And I think I'm running out of time, so I'm going to hand it over to Stephen. Thank you very much.
Thank you, Michael, and hi everyone. I'm Stephen Schoeninger. I lead the employment and workplace practice at Avant Law as part of Avant Law's newly expanded commercial legal service offerings. We've got great teams across 4 new commercial practice areas: commercial and corporate, property and estate planning, as well as employment and workplace. In the employment practice, we advise on all areas of employment and workplace law and litigate employment and workplace disputes. Big thank you to PracticeHub for inviting me along today to take you through some key legal issues relevant to casual employees. There are 3 broad areas that I'll cover. I'll start with important statutory changes arising out of some significant case law and what they mean for you and some action items arising. I'll then give you a quick refresher on the parameters of the award as relevant to casuals in medical practices. And finally, I'll go over in a bit more detail the obligation to assess casuals for eligibility to convert to permanent employment. That's part of the statutory changes that have tweaked pre-existing award casual conversion rights that some of you might be aware of. So to start off, in recent years, there have been a series of quite significant federal court cases that highlighted legal risks for employers associated with casual employment. They arose in circumstances where quite often long-term casuals had ended up working effectively as permanent employees, for example, on a full-time basis or on a permanent part-time style basis, so that there was a blurring of the nature of the employment relationship, which enabled the casual employees in certain circumstances to claim that they were really permanent employees at law. The result of that being that they were able to claim back pay from the business for unpaid entitlements to annual leave and other types of leave and other benefits of permanent employment that casuals don't receive because they get casual loading. The key thing that arose in those cases was that where casual employees were being held by the courts to be really permanent employees, they were able to double dip effectively. Having received the benefit of 25% casual loading, the courts were still awarding them where they were found to be really permanent employees. For example, many years of back pay of 4 weeks annual leave a year, for example. So there was quite a significant area of exposure. The High Court, these cases went on for a couple of years and went all the way up to the High Court. And the High Court very helpfully cut through a lot of the legal white noise and held that the contract of employment is what defines the employment relationship, so that if you sign up to a casual employment contract, you're a casual. Simple and very helpful. But at about the same time, the government stepped in and threw a little spanner in the works by making some amendments to the Fair Work Act that came into effect in late March last year. And the key one of those was to include for the first time a statutory definition of casual employment in law. And that lives in the National Employment Standards within the Fair Work Act. Because that statutory definition has been included, it's really important as an action item to be reviewing your casual employment contracts to make sure that what you have called casual employment in your contracts is marrying up with the new statutory definition of what a casual employee will really be at law. provided that you are marrying up your contracts with the statutory definition, you're going to be on really good ground to be employing casuals to work flexible hours as required to fill the gaps in your business without that ongoing risk of potential residual claims where work arrangements do change over time. So in terms of the amendments, the new statutory definition of casual employment says that you're a casual if an offer of employment is made to a person on the basis that there's no firm advance commitment to continuing an indefinite work or set hours. That fits very neatly with the classic common law and commonly understood definition of casual employment. But if a person is made an offer that says that there's no firm advance commitment to continuing indefinite work and that offer is accepted, you will have a casual employment agreement in place, and that casual employment remains casual employment forever until you agree to vary the employment to, for example, become a permanent employee, if that were the case. But even if in practice the person ends up working for you quite set hours, they will still be a casual and won't be able to come back and make a claim against your practice for unpaid leave entitlements or other benefits. So that statutory definition is really important, and it applies to all casuals who you've employed from March last year, but including existing casuals who've been with your business for longer. The important caveat is that in relation to your existing casuals, the offer of employment made to them does need to be consistent with the new statutory definition. So again, the High Court has said your contracts are the primary document. The legislation has now said the contracts should be saying this to properly define casual employment. So we need to make sure those two marry. So if you haven't been through the exercise of reviewing casual employment contracts since March last year, it's a really important thing to do. It's a quick and easy fix to make sure that you are complying and protecting the business moving forward. The legislation also now includes an obligation to give casual employees a casual employment information statement. This is an additional document that's just like the Fair Work information statement that you'll be used to giving all new starters. You can find it on the Fair Work website that I've referred to on the slide. Casual employees are given the casual employment information statement as well as the Fair Work information statement. That's for all new casuals. For existing people who were employed casually before March last year, if you haven't already given them a copy of that document, you must do so. So go to the website and you can download a copy of the statement to email or print off and give to people. The new legislative change also includes a new statutory rule that basically addresses the problem that we saw in the cases to say that in circumstances where your contract might not be up to scratch, relevant to the new definition, and a court then says that a casual employee is really a permanent employee, they can't double dip. So the statute now says the courts must take into account any casual loading paid to an employee to offset that against any claim they might have for permanent benefits. So for example, back pay of their annual leave. Finally, the legislative changes introduced a new statutory casual conversion regime. This provides a pathway for eligible casuals to convert to permanent part-time or full-time employment where they're eligible to do so. And I'll come back to that shortly. So before I come back to casual conversion, I thought it might be helpful to just take a moment to refresh ourselves on the award rules for medical practices around the parameters of how you can engage your casuals. Remember that you cannot contract out of an award. They set the minimum terms of employment for people covered by the award in the industry. On the slide, we've got a summary of the relevant casual parameters for the Health Professionals and Support Services Award that you're no doubt familiar with. Where you're employing nurses, the Nurses Award applies to nurses, obviously. But in terms of, for example, receptionists or other people covered by the Health Professionals and Support Services Award, a casual is able to work up to 38 ordinary hours a week. There's a minimum 3-hour casual engagement or 2 hours where if you're employing a casual cleaner in a private medical practice. We had a question before the session from a person asking whether you can reduce the working hours for a casual employee. Absolutely you can. That is the point of casual employment. So provided that you have an employee on a contract who is properly engaged as a casual, you are able to flex their hours as required to meet the needs of the business. To say, I need you for 10 hours this week, I need you for 5 hours next week, 20 the next week after, whatever it is, within the scope of hours or the parameters set out by the award. So the minimum engagement is always going to be 3 hours, but you can then adjust the hours. The caveat for the person who asked the question in relation to reducing casual hours will be careful if they were an existing casual whose contract isn't complying with the new laws. If they've been around for some time and they were really permanent and their contract isn't meeting that casual definition, you could have some problems. And so it's probably worth getting some specific advice. And I'd be happy to help review the contract if you'd like to get to the bottom of that. Moving back to the award for our casuals for ordinary hours, they're paid the casual loading of 25% that compensates them for the leave entitlements, etc., that they would be paid otherwise as a permanent employee. Overtime can be worked, and the award specifies the relevant overtime rates that are set out on the slide. Those rates are inclusive of the loading. So the award, as it's been modernised for 2020, very helpfully gives you sort of the set amount without you having to jump backwards and forwards to work out what applies where. A little trip is to be careful that where overtime is being worked, make sure that the casual is then getting 10 hours off duty after they finish overtime before they're starting another casual shift the next day. If you require them to work without that rest period, you've got an obligation under the award to pay them 250%, double time and a half, until they're then released from duty. So that could get quite expensive if they're rolling onto a whole new shift without that proper break. So those are key elements of the Health Professionals Award as it applies to casuals. As again, you might have nurses. There are different minimum hours, overtime and penalty rates for casual nurses under that award. So make sure that you are across those. The final big issue that I wanted to go through with you in relation to casual employment comes from the statutory changes that I referred to, but it's the casual conversion piece and how that works. The laws are really prescriptive, and you need to be quite diligent in record keeping and diarising these steps because they apply to you for all of your casual employees. Casual conversion isn't new, but the rules that changed, there used to be casual conversion provisions in a lot of modern awards, and they've been there for several years. So you might already have some experience in dealing with those, but they have, in being moved from awards into the National Employment Standards, been changed quite a bit, and they're very prescriptive for employers. So it's important to be aware of them. There are different rules depending on whether your practice is a small business or not. You're a small business for the purposes of employment law, the Fair Work Act, if you have less than 15 employees. And if you're part of a corporate group of a number of companies, it's not just of the particular company in which you work, it'll be 15 employees in the group of companies. So if one particular company has 5, but there are 50 across a group, you're not a small business. But if there are less than 15, you are. For businesses that are not small businesses, so if you have 15 or more employees in your particular practice, including within a corporate group, you have a positive obligation to assess all casual employees for eligibility to potentially convert to permanent part-time or full-time employment on their 12-month anniversary of casual employment with you. And importantly, for any casuals that you had before the 27th of March last year, which was the magic date when the amendments to the Fair Work Act came into effect, you must have already done that exercise by the end of September last year. So for all existing casuals before March last year, you must have been through the process of assessing them for eligibility to convert to permanent employment and have corresponded with the casuals about that before September. If you haven't, give me a call and we can work out how to get you back on track. Assuming that's been done though, these rules apply for all casuals moving forward. So as an action item, a critical thing is that for each new casual employee that you employ, you want to be diarising, say, 11 months out from their start date to remind yourself that, I need to be speaking to the relevant managers, supervisors, getting an understanding of how this person has worked, to be assessing them against the criteria set out in the legislation to determine if they're eligible to convert to casual employment. And you need to be writing to the employee to let them know that you've done that and whether you have found that they are eligible and that you will be offering them conversion, or that you've assessed them and they're not eligible, or that if they were eligible, you've got a reasonable business case as to why you can't convert them in the particular circumstances. So that positive obligation it's quite onerous, and particularly if you've got quite a large casual workforce and there's a bit of turnover, it could be something that is potentially coming up quite regularly to need to review the particular employment of an individual. They're going to be eligible to be offered conversion if they've worked for you for 12 months. In the last 6 months that they've been with you, they worked a regular pattern of hours on an ongoing basis. And they could continue to do that or work broadly in the way that they've worked as a part-timer or a full-timer moving forward without significant change. So you need to look at the practical realities of how the person has worked and whether effectively, if they've been really working full-time, they can continue to do so with perhaps some tweaks, but nothing substantive. If you're not going to be offering conversion, you need to have reasonable grounds not to do so. And the legislation gives very specific examples. It can't just be that I don't want to do it or that it's too hard and I don't want to be bothered dealing with casual conversion. It is compulsory and reasonable grounds need to be substantive. So a classic example would be, that the particular position will not be required moving forward, so it'll be redundant effectively. You won't need that role. In those circumstances, you wouldn't convert them. Or you've seen in the particular area of the business where they work that, look, we're really seeing a particular downturn in that area. I'm not sure that they're going to be necessarily redundant, but I'm not sure that I can, it's quite likely that if they stayed casual, I'd be reducing their hours moving forward. And so I don't think that it's commercially sensible to be offering them a permanent gig, even a part-time permanent gig, on the basis that they have worked moving forward. But you need to have some real and substantive and defensible grounds to be able to resist those. And we need to be critically writing to our casuals to be explaining our reasoning to them. And those letters are really important because they're going to be open to scrutiny by the Fair Work Commission, potentially, because there are provisions for disputes to be brought if people don't agree with your assessment. So you need to put a bit of time into it. So it is onerous, but it's a sort of thing that you'll hopefully get into the swing of doing. But effectively, the purpose is that where someone is effectively permanent, they should be able to work permanently moving forward. So I think diarising those key dates is really important. There are also prescriptive timeframes of 21 days for various steps of after the 12-month anniversary, you have 21 days to write to the person. They then have 21 days to come back to you with their views. You then might have to engage in a consultation with the individual before you give them an offer of permanent employment, a new contract moving forward. There are significant penalties of up to $66,000, $600 for a company, and $13,320 for an individual for non-compliance with the Fair Work Act across the board, and also for the awards. So that's the standard penalty for breaching any of the award provisions. They apply in all these cases. So significant penalties can apply. We're here to help if we can. It can get a little bit confusing and onerous, but once you've got a process down pat and you've done this a couple of times, hopefully it will become second nature. I can see that we have a bunch of questions come through. Let me just firstly address a question that came through prior. So for a casual who has become a part-timer, is it okay to pay someone was casual, who's become part-time, casual rates, as long as they sign an agreement that they want to be paid casual rates moving forward rather than be paid sick leave and annual leave instead of paying the lower part-time rate? No, that is the short answer. These penalties apply for any breach of workplace laws. The award applies as minimum terms of employment for all employees. So a part-time employee covered by the award must be employed in accordance with the award as a minimum, and a casual similarly must be employed in accordance with the terms of the award as a minimum. A part-time employee who you agree to give casual loading to, therefore, cannot lose their statutory entitlement to annual leave and sick leave, personal carers leave, no matter what you agree. So if you agree to do that for that part-time employee in those circumstances, the effect of it is that you're really giving them a 25% pay rise because you are still giving them the casual loading, but they're also legally entitled to the annual leave and all the rest of it. So I wouldn't think that that's a good idea to agree to that. You certainly shouldn't agree to that. You're exposing yourself to risk and really just overpaying that employee. Of course, award rates are minimum rates. And so commercially, you can pay people whatever you like as long as it exceeds the statutory minimum. But any agreement to try and forego the leave certainly wouldn't work.
I'm not sure.
Can a casual employee be paid for less than 3 hours if it is for an optional staff meeting? No, great question. So staff meetings, training, anything like that is work. So it is for you as the employer to manage the workplace and workflows, including the timings for which you choose to hold staff meetings, compulsory or optional. But if a meeting is going to be held outside of hours and people are going to need to come to that for work purposes, they must be paid a minimum of 3 hours. So it'll be something to think about in terms of when the timing of those meetings. You probably want it to flow directly into the workday to avoid that cost. But if there is an out of hours meeting, it's a minimum of 3 hours per engagement, and we cannot contract out of that. How much notice do we need to give casual staff about shift changes? It depends how you're working. Usually you're going to get into quite a routine with your casuals. You may well have relatively regular hours that you're working them. If you are doing, for example, weekly rosters, would be saying to the people, hey guys, for the casuals, can you work Monday, Tuesday, Wednesday, between X and Y, yes or no? But the nature of casual employment is that it is there to be flexible and to fill in the gaps. And so extending shifts or cutting a shift short where it is required, where it needs to happen, is completely fine where the business needs that to happen. The rates for casuals in medical only working Saturday, Sunday and public holidays. I don't have the actual specific minimum rates. The minimum rates are set out in each of the awards. If you go to the Fair Work Commission website, fwc.gov.au, and look up the modern award, the rates are specified there as a minimum. All casuals get 25% casual loading, and at weekend penalty rates apply, or overtime rates can apply, as I set out on the screen.
Stephen, there's quite a few comments in there I notice around people saying, what about if the staff member doesn't want to accept the offer to convert? I see on the slide it says they have the right to apply again, and I think somebody said you have to keep offering it every 12 months. So
yeah, absolutely. Great.
What if they knock it back? What next?
Great questions. Your obligation as an employer is to make the assessment and to offer it where eligible. The employee does not need to accept it. So you could have gone through all of this work and thought, oh, yep, I want that person full time. They can say no because they've contracted with you. An employment contract is like any contract. You can't just change it unilaterally. You've contracted with this person to be a casual, provided you've done it properly, consistent with the statutory definition. Then the person can say, no, I'm quite happy as I am. I'll collect my casual loading. I won't get leave. I'm happy to work these hours moving forward. And that's completely fine. So they don't need to agree. If they don't agree, they can't change their mind a week later. Things will stay the same for 12 months. So after 12 months, though, the obligation to do this exercise is a one-off exercise for each casual on their 12-month anniversary of starting with you. So if I start as a casual employee in your practice, at my 12-month mark, you will go through the casual conversion review exercise. If I'm eligible, you offer it to me. I say, no, thank you, I'm very happy. Then I can work with you for the next 20 years and nothing will change. You don't have to do anything more. I, though, maintain a residual right to come back to you after 12 months to say, hi, actually, I have been working on a full-time basis, and now I think of it, my priorities have changed. The casual loading's been great to get the extra cash in my pocket. With my age and stage, it would actually be really nice to get the leave and so forth to help me manage my life and my family and sick leave and whatever it is. And so I'd like to have a conversation about conversion. If the casual employee comes to you and says, I'd like to convert, that then triggers your obligation to go through the review process to see if they're eligible. They might say, I want to convert. If you assess them and they're not eligible, they won't be eligible, but you're going to have to go through that process. In relation to small business, I should say, and thank you for the question, you don't have a positive obligation. So if you have less than 15 employees, you don't have the positive obligation to do this exercise, but your casual employees can come to you at any time and say, hey, can you please consider me for conversion? And if they say to you, please consider me, then you need to go through that exercise. Where you've gone through the exercise and they then reject it, they have to wait 12 months. So it's a one-off exercise at the 12-month anniversary date. You need to do it. Once you've done it, you've ticked your boxes. They're either going to convert and you're going to make an offer of casual and permanent employment to them moving forward. Or if you make the offer and they say, no, I'm very happy as I am, that's fine. They continue as they are as a casual employee, but they maintain a residual right to come back to you and ask the question, down the track. So I think that's hopefully answering a lot of those questions.
I think so. Stephen, I guess in the follow-up to this webinar, we'll be sending some links to some resources. So things like doing that flow for the conversion. There'll be some information we'll be able to include to attendees today.
Absolutely. The legislation sets out the steps and we can send some information out around that. We're helping a range of clients with putting together template letters and so forth. Particularly, if you're a larger employer or you have a decent number of casual employees, and so you expect to be going through this exercise. Quite recently, we've been helping clients with preparing template letters that are complying with the relevant rules in terms of making offers of conversion, or more importantly, and a bit more from a bit more challenging perspective, explaining what your reasonable grounds are where you're rejecting casual employment. So again, you need to be look through the information that we will send out to you afterwards. Get in touch if you've got any concerns or questions, because the reasons you give are potentially open to scrutiny, and they do need to be backed up with some real evidence. So it's not enough to just sit there and say, look, no, I just don't want to do this. I don't like it. Doesn't sit well with me. You need to be able to articulate as the employer why you have a reasonable ground not to make the offer of conversion.
Mm-hmm. Terrific. All right. And it sounds to me like with the changes that took effect last year, it's really imperative that people have the right documentation. And
it certainly is. So review your employment contracts for casual employees. If they're compliant, that's great. If they're not, it exposes your business to real risk. It's a quick review to make sure that they've got sort of some magic words to be lining up beautifully with the statutory definition to avoid risk and ambiguity. You must have been through the conversion review process for all existing employees you had before March who were casual. If you haven't done that, you should have, and we should have a conversation about remedying the situation. And get into the habit of diarising those 12-month anniversary dates for your new starters moving forward.
Very good. All right. In the interests of time, if it's all right with you and Michael, I might flick over to our PracticeHub demo very quickly, where I will hopefully tie in a lot of what we've talked about today with how PracticeHub can help. So let me just go to my screen here. So I think one of the things that Michael said that really stuck with me is that regarding recalls, was all the team needs to know the whole system. And so I think that a really simple way for practices to do that is in the manual. So PracticeHub, I should go and show you our dashboard quickly, has a range of applications. Some of you I know who are attending today already have it. Those that don't, it's a suite of different applications to help you run the operations of your practice, including things like your policies and procedures and inbuilt compliance, audit trail, all of those things that form part of the platform. But when it comes to, I guess, keeping people aware of how things are done, the policy and procedures manual is probably the place to go for that. And one of the things that we do as PracticeHub is we can provide our clients with a suite of templates for a lot of the policies and procedures around that. And you can see here we've got ones around the recall system, following up test results, what happens with high risk results that are received out of hours, and just basically managing those results. So it's really important to have this information, and having it sort of documented and available for everybody. It means that it is transparent, it's consistent, everyone is reading the same information, understanding it. And the other thing that, of course, you can do is get people to electronically sign off that they have read and understood the policies and procedures. Now, this version I'm showing you is it also includes links to the GP standards, but regardless of what type of practice you're working in, a recall system is obviously really an important aspect of running your practice. So important to have that information available. I think this one here will show you if you need the members of your team to sign off on the policy, you can flag that. They'll be alerted. They'll see a little banner saying you're required to read this. And then down the bottom for that particular user, I've read and understood and agree to comply. And when they click on confirm, you'll now have an audit trail that the date, the time, the user who has signed off on that policy. And then similarly, if anything changes, if you change the way you do it, you do a review of your system, which of course you should be doing regularly. But if as a result of any review, you update the policy and procedure, you can then prompt your team members to go back in, read it, and sign off on the new version as well. So that's a really important aspect of having good policies and procedures to support your systems and processes as well. And just on a note about Stephen's presentation as well, including a page in your manual relating to the Fair Work and the awards and things like that, and including links in there. So this one here, we haven't quite got around to including the casual employee information statement, but we can put a link to that in. So apart from obviously making sure that new starters get that information, you can also make it continuously available should they need to go back and refer to it very easily as well, along with links to the relevant standards and the employment standards as well. That's just a very quick sort of link of the items that we have in PracticeHub that relates to our conversation today. I will come back to my presentation. So next steps, if you're already a PracticeHub client, don't forget to contact our team who can provide you with additional support. If there's any parts of the system you would like to understand better, please contact them. If you're not a PracticeHub client, the best way to find out more is to book a consultation with one of our team. We'll be able to do a one-on-one discussion with you about your practice and how PracticeHub can work with that. Please visit our website at practicehub.com.au, where we have articles, recordings of other webinars, and you can contact us via the live chat on that website as well during business hours. Keep an eye out for our upcoming webinars. Next month's webinar is on managing your team's mental health, and we have an excellent speaker for that. Any questions from today, please go to info@PracticeHub. Any questions for the Avant Law team, please go to info@Avant Law, or alternatively visit their website. Just to wrap up, can I thank Stephen and Michael very much for your presentations and your input. I think it's been really interesting. I can see we've had great interaction from our attendees. So thank you very much for that. And to our attendees, thank you for giving us your time and participating. And we look forward to seeing you next time.